Hi everyone, and thanks for coming along today. So I assume everybody has an interest in intellectual property and finding out a bit more about it. And that's what the purpose of this presentation today is, really to give you a broad overview. What is IP? What are the different types of IP, and how are they relevant to you in your individual roles? So I hope this will be really informative for you. I had the privilege really of going to the Intellectual Property Office in Newport recently and undertook their masterclass. So I've had a real kind of a good immersion into the world of IP, and it can be, I think, from the outside, a bit of a complicated place. And people get a bit nervous about IP, and that's what this session is for, really, to demystify some of the types of IP so that you feel confident about how you can protect and use your IP to your advantage. So I think if we start at the beginning, what is intellectual property? So there are a number of different types of IP protection. Intellectual property is just a collective term for creations of the mind, and that's very broad, and the types of protection available to you are very broad. What we're going to cover today are trademarks, registered designs, patents, copyright, and then we'll touch on unregistered design rights, confidentiality, and trade secrets. So that really covers the formal and the informal types of intellectual property protection that are available to you. So we're going to start with trademarks, and the reason that I'd like to start with trademarks really is because they're one of the easiest forms of IP for people to understand, and that's because we interact with them every day. Trademarks are everywhere and they're really broad, so all of us are consciously or unconsciously aware of them. And they do encompass a much broader spectrum of things over and above logos, which is perhaps something that we're quite familiar with. So a trademark can be any sign which is capable of being represented graphically, any sign which is capable of distinguishing the goods or services from one undertaking from another, and it can be a badge of origin. You'll recognize trademarks from the R, which means a design is registered. You may also be familiar with TM. TM has been nicknamed totally meaningless by some because TM just means that something is being used as a trademark, but it's not registered and it's not protected. So R is the one you're looking out for a registered trademark. What can be registered as a trademark? So as I said, it's extremely broad. So you can register a name as a trademark, a logo. So the tick on the screen there, you'll recognize as Nike. So that's a very strong trademark. There's nothing else there apart from that little black and white tick. And we all know what that brand is. A domain name can be registered as a trademark. So DIY.com on the screen there is a registered trademark for B&Q. A slogan can be registered. So I'm looking at Carlsberg here, so probably is one of their slogans, and that's trademarked. A shape theme, so we might be looking at perhaps Toblerone as a shape theme. So that's very particular to that brand of chocolate, and if we look at that chocolate, we know that it's Toblerone without having any other information. Colour theme, so Dairy Milk registered their Cadbury Purple as a trademark. It's becoming increasingly difficult to register trademarks like that, but it has been done. And if you used Cadbury Purple in the past, certainly you'd been infringing on their trademark. An action or a motion can be trademarked. So on the screen there, you'll see the tap, which is the Asda Price trademark, and that's an action. And music, so you may recognize from some advertisements, particularly around Intel is a good example. There's a little tonal inflection there, and that's registered as a trademark. It needs to be distinctive for the goods and services that you provide. So virtually anything can be registered as a trademark, but it has to be capable of being represented and being distinguished. You can't register anything which particularly describes a product. So you couldn't register, for example, silk as a trademark for a tie, but you could register Hannah's silk ties as a trademark. Made up words make particularly good trademarks, and good examples of those would be Kodak or IKEA. As to words that have nothing to do with your product, which perhaps sounds strange, but if I give you the example of Apple for electronic goods, that's an excellent trademark. So what are the benefits of having a trademark? Well, in the UK, a trademark registration gives you the right and the exclusive right to trademark goods and services. And it's really important when you trademark that you define the scope of the protection that you're seeking. So when you register for a trademark, you will apply using the NICE classification system, and that simply means that there are a list of categories and you select the categories that are appropriate for your trademark application. And that means, generally speaking, you wouldn't apply for all of the sections, although some very large businesses, for example, Sky, they've trademarked across all categories. Generally speaking, it's not advisable to try and do something like that for two reasons. The first being that you're likely to bump into a trademark in another category. And the second reason, she says, losing a train of thought, and the second reason for doing it is that you have to demonstrate in the first 5 years that you are using the categories that you've applied for. So if in the first 5 years you haven't done anything, there's been no commercial activity in a category that you've applied for, then you wouldn't be able to continue to use that category under your trademark. When I talk about categories, they're simply categories of goods. So there's categories 1 to 34, which classify goods, and categories 35 to 45, which categorize services. The reason this categorization is really important for trademarks is because you might successfully have registered the same trademark in 2 categories, and that might be registered by 2 completely different businesses doing 2 completely different things, and that's perfectly fine. So a good example of that would be Polo, and that's a registered trademark in confectionery for the Polo mint and a registered trademark in automotive for the car. And it's deemed that as those things are so distinct and so different, that's not a conflict of interest. Once a trademark's been submitted, you can't make any changes to it. So it's really important at the point you submit your trademark that you're very sure about what you want it to look like or to sound like. And a registered mark gives you the right to stop others from using confusingly similar marks for their goods or services. And that's why it's really important, because once you've registered a trademark, you own that trademark and you can stop other people from using anything which is either the same or confusingly similar. It also allows you to sell or license a brand. So if you build up a particularly strong brand, you can license that out for other people to use. Again, there I've put, it allows you to use the R symbol, the registered trademark symbol next to your brand. And that does warn other people, you know, you can't use this for your own use. This is a registered, protected trademark. And in the same breath, allows you to take legal action against anyone who's going to use your brand without your permission. How much does a trademark cost? Well, I've put the costs there, and these are the costs for different trademark registrations. In the UK, you can file a series of 2 trademarks for a flat fee of £170. What I mean by a series of 2 is you can file 2 linked designs. So for example, you might have a trademark which is a standalone brand name, and then you might have the same trademark brand name with a graphic element attached to it, and that would be considered to be a series. A series wouldn't cover, for example, your text logo and a completely separate graphic element which doesn't appear on your text logo, because those 2 things are distinct. There is no commonality between the 2 trademarks that you're filing. But a series of 2 can be filed for £170. There's also something called a right start service, which is really good if you've never registered a trademark before, because it breaks down that cost into 2 parts. You would pay £100 for a search, and I'll show you how you can search for trademarks. After the search has been completed, assuming that there is nothing that exists which might create an issue for your trademark that you're trying to register, you can pay a further £100, so £200 in total, to proceed to an application. So if you want to de-risk the process, if you've never done it before, you can break it down into those two parts. Once you've filed a trademark, there's a 2-month objection period, and objections can be raised if your trademark is identical or confusingly similar to an existing mark on the register, and that will be interpreted by the IPO. Once you've filed a trademark for your £170, you get 10 years and you can pay to renew your trademark indefinitely. So if you're building a brand, if the brand is integral to what you're doing as a business, that is a really good way to protect what you're doing, and extremely good value for money if you choose to renew it indefinitely. Important thing to remember with trademarks is a trademark belongs to whomever's name is on the application. So if that's an individual name, the trademark belongs to the individual. And if that's a business name, the trademark will be assigned to that business. Once you've registered it and that registration has been filed, the trademark can be sold or reassigned because essentially it's become a piece of property. A warning around trademarks: there is something called trademark squatting, and that refers to somebody who has claimed something which can be used as a trademark. So it might be your logo that you have, which is unregistered. They can claim it, register it, and trade off the back of it, and that's called trademark squatting. It's also common with trademark squatting that the person has done that with the exclusive purpose really of selling it back to you, and at that stage they can name their price because they have rights to that trademark. So it is worth thinking about if what you do can be trademarked. If you have a logo or a slogan or something that is particularly important to what you do day to day, you can register that as a trademark and protect it. So as I said, you can register, you can search for a trademark online, and that's something that anybody can do. So you can access a search through the Intellectual Property Office. It's really important to do this. I think even if you're not intending to register a trademark, you can see if you're infringing on the trademark of anybody else, if you are using something, especially in your particular area. So if you're doing something, you're providing a specific service, you can search for trademarks in that specific service area, so in the niche category that you would perhaps register a trademark in if you were going to do that, and it'll show you if there is anything that's either identical or confusingly similar to something you're already using. And that is important because people can come back. If you've established a brand on the back of a trademark, which might be a logo, and you've been doing it for 10 years, but it turns out somebody was already using that logo, they have the permission to use it and you don't, which means you'd have to stop using it. And if that's integral to your brand, it's really damaging for your business. It also means that you can identify who owns a trademark if you're seeking an early resolution of any potential problems. So it might be that somebody's registered a trademark, but they haven't used it, or they're no longer using it, in which cases they can sell it to you so that you can use it for your own business. So moving aside from trademarks, we'll move on to registered designs. So registered designs are a little bit different in that they protect the visual appearance of a product. And that visual appearance protection can cover lines, colour, shape, texture, contours, material, and ornamentation. On the slide there, you'll see physical shape, so it covers a number of those. Configuration, so how different parts are arranged together, and the decoration of a product. So that might include the pattern on a fabric or the materials that you've used. And it can protect how a product functions. A good example of a registered design would be, you're probably familiar with Cath Kidston or Emma Bridgewater patterns, and they're very unique to that brand, and they're protected as a registered design, so other people can't use a similar pattern on their products. The shape of a Coca-Cola bottle is also a registered design. I think that would be quite difficult to register as a design now, but at the point Coca-Cola registered it, it was possible to register the exact shape of that bottle, so you won't see any other bottles with the same shape as Coca-Cola. A registered design can't protect what material a product is made from, how it's manufactured, or a form dictated by its function, and we call that must fit or must match. So for example, a key has to be a certain shape in order to do its function, and therefore you couldn't register the design of that key. Or standard attachments, so you might think about a USB connector. A USB connector has to be a particular shape, and therefore you couldn't register the design of that shape because it's a universal attachment. One of the best ways, I think, to understand a registered design is to understand the differences between a registered and an unregistered design. So much like trademarks, registered designs exist on a register, so they are formalized. You make an application to the IPO in the UK, or you can do the same for a European or a worldwide registered design. And with the IPO, that registered design would last for 25 years. Importantly, the onus on a registered design is on other people to prove they have not infringed on your design. And if I skip across to an unregistered design, there's the key difference really. If your design is not registered, you have to prove that somebody else has infringed your design. So the onus is on you rather than the onus being on the other person. Essentially, when you register a design, you've said, I've done this, it belongs to me, and other people don't have that date stamp and that formality which proves that they own that registered design. So it's much more difficult for them really to prove that they own the design and that they're not infringing your design. With a registered design, there are criminal sanctions, and it covers 2D and 3D protection. So unregistered designs, they're an automatic right. So if you've designed something, you have an automatic design right over that product. And it lasts between 10 and 15 years. Obviously, then you have to prove at what point you created the design. So you need to formalize that design in some way. When we were at the IPO, there were a number of examples given where things had been emailed and that email gave a timestamp on something. But again, you need to be a little bit careful who you're emailing things to if that's the way that you're going to formalize things. Otherwise, you might want to create an IP inventory or register and formalize your IP that way. But it's important really to draw that up and show that you've designed something if you intend to use an unregistered design right, because you're not listed on a register. The license of a right, an unregistered right, is automatically granted to other parties. There are no criminal sanctions, and it only protects a 3D shape. So really a registered design gives you a lot more protection, and if you want to simplify it, the real key to that protection is the onus on other people proving that they had that design before you did. An example I've just drawn upon here really in terms of registered and unregistered designs. So you'll be familiar probably that there's a lot of online selling now. So if we think about a small scale online seller who has designed a new product and they're selling that on the internet and anybody can view it, it's very easy for somebody else, particularly large companies, to look at that design and copy it. If that's an unregistered design, you're then faced with the issue of trying to prove that a very large business with a lot of collateral, legal collateral, has stolen your design. If you've registered that design, you have a date stamp which shows A, that you created the design, and B, when you created it. And the onus then would be on those larger companies to prove that they designed something that exists on the register which you're infringing on, and that would be very difficult for them to do. So that's a good example, particularly around, there are a number of garment sellers recently who are selling very high-end garments on the internet, which they've designed themselves, and they have alleged that larger retailers have stolen those garment designs and are selling them at a budget cost on these large online clothing retail sites. So if you haven't got a registered design, it's not protected. How much does a registered design cost? It's really good value for money. So in the UK, it's £70 for up to 10 designs in the same application. So you can bundle a whole load of designs together. So if you're a product designer, if we go back to the garment example, if you've designed 10 different garments, you can register those all in one go. They don't need to be linked, and it's £70 for that application. And once those have been processed, they appear on a register, and that gives you the kind of signed, sealed proof that you have created that design. I'm going to move on now, and if we can park really the creative and move on to the technical, that's where we are with patents. And if you can take only one thing away, distinguishing patents from other forms of IP protection, they are for technical inventions. So patents, as I've said, protect technical inventions, and they need to be new and inventive at the point the patent application was filed. Patents are incredibly complicated, and unlike some of the other forms of IP protection that we'll talk about today, certainly trademarks and design rights, which can be fairly straightforward, patents are quite complicated, and that's because they're protecting a technical invention. And in order to protect the technical invention, you have to specify exactly what that technical invention is, and the level of specificity that is required with a patent application is very technical. So I would say with patent applications, particularly with patent applications, it's inadvisable to proceed with a patent application without seeking some specialist advice, because in doing so, you risk revealing your secret without protecting it. But I'll talk a bit more about that later. What's the benefit of a patent? Well, it gives the owner an exclusive right over the invention for 20 years, which can create a huge competitive advantage. Really, what a patent is doing is creating a monopoly. So if you file a successful patent, you have a monopoly over that technical invention, and that can be really lucrative. As I've touched upon, really, patents are granted in exchange for full disclosure of the invention. And in general, the details of the invention are then published and made available to the public. So you do have to think carefully before pursuing a patent about whether that's the right thing for you to do, and certainly you can seek some more advice around specific things that you might be working on where you feel a patent might be appropriate. But really, it's great to have another opinion around that. Patents can be very useful, but they can be a bit of a nightmare, and you need to weigh up the pros and cons of pursuing a patent before you go down that road. Interestingly, 80% of technology they believe is locked up in patents, so a lot of technology is patented. If you're thinking about filing a patent, there needs to be a clear inventive step. So you can't put two existing ideas together and say it's new. There has to be an element of invention in there. We get a lot of questions about computer programs. So if a computer program affects something in the outside world, it may be possible to patent that computer program. If a computer program is really creative, it can't be patented because there's no technical effect or outcome. And with apps, we get a lot of questions around apps as well. Often apps will be considered that they are just presenting information that already exists. And so if you're thinking about an app, a lot about what an app is creative. It's not necessarily the technical aspects of that app. And patents are technical elements, so it would have to be something very distinct and unique to be patentable. So what can a patent protect? So new inventions, how a product works, and its technical function. So what does it do and how does it do it? Again, the criteria for patentability, something must be new and novel. Really important, prior disclosure invalidates a patent application. So if it can be proved that you disclosed in any way the concept, the technical elements that are specified in your patent application will be void. And that's really important to think about, particularly if you are sending emails. So if you've disclosed particulars about something which you later intend to patent in an email, and that email is found, or somebody shows the patent office that email, your patent will be void. If you've spoken in public, if you've had conversations with people, and people can prove that they knew about your idea, it can't be patented. It has to be completely novel. It must be an invention. So as I said, it must be inventive, but it could be an inventive step. So it could build upon something that already exists, but it would have to be an inventive step. It couldn't be two things that exist together. And it must have a technical effect. So just drawing back, really, it can't be something that's purely a creative presentation. It has to have a technical effect. Really important, you must include all of the information at the point you apply for a patent. You can't make any changes or add any additional information after you've filed a patent. And I would say in the main, that's true across all IP registrations. So at the point that you submit the registration, whatever it is that you're trying to protect, be that a trademark or be it a patent, it needs to be complete. You can't go back later and say, oh, I forgot to put something in. It won't wash, so it needs to be complete at the point you submit it. The patent process, so unlike some of the other types of IP protection, which are relatively straightforward, the patent process is quite lengthy. To simplify it, we could divide it into two parts. Part one would be the patent application, patent searches and claims. So clearly you need to put a patent application together. Searches refer to the process of searching through existing patents which prove prior art, which show that your technical step isn't novel. So it's important that those searches are done. And if we think about patents and how very particular patents are, you can really get the feeling for how long a search might take, because it's very technical. Claims, so when I talk about application searches and claims essentially ring fence what is in and out of scope with your patent. And you as the applicant and the IPO may review the claims many, many times to ensure they're really accurate and specific. It sometimes happens in the process of writing the claims that the patent becomes so specific that actually it's no longer useful, because perhaps your first patent, your first draft of the patent is quite broad and it's infringing on other patents, or it can't be proved that what is in your patent particularly describes what it is that you've designed. It has to be very, very specific. After the application, the searches and the claims have been complete, you can file a patent and you'll have an A-class publication. And that would look like the patent title, the name of the applicant, the date of filing, the date of the publication, and the patent number. And that means a patent has been applied for, but it hasn't been granted. Part two is the substantive examination, and that really takes a very long time, and it can last a few years. So you'll see on the graphic I've put on the screen there, 4 to 6 years is what the IPO have indicated for the substantive examination. Now that doesn't mean your patent doesn't exist. Your patent has been applied for, it has a patent number, you can prove that you filed it and when you filed it, but the patent hasn't yet been granted. So the IPO are not yet convinced that the patent is completely novel and doesn't infringe on other patents, or people might raise issues with your patent. just out of interest, really, the shortest time, which part 1 and part 2, so the initial application and the substantive application, substantive examination being completed, the shortest time for that would be a year. That would be in very rare circumstances, when a patent is fast-tracked, when it's perhaps it's in the national interest. But usually it's going to take several years, and that's an undertaking that you need to consider really at the point you file a patent. At the point the substantive examination is concluded, you get a B publication. So moving on from your A publication, which is that you've applied for a patent but it's not been granted, the B publication includes more information about your patent, and it gives you patent granted status. So patents are really good if you have got a very novel technical invention, particularly in cases where your technical invention could be reverse engineered. And I'll talk about that a bit more in the next slide, perhaps. In terms of costs, this can be a little bit misleading. So in terms of the actual costs for registering a patent, it's around £310 if you're applying online, which seems really good value for money. But I think, as I've alluded to, really, it would be ill-advised to pursue a patent without employing a patent attorney to assist you, and patent attorneys generally cost in the region of £3,000 to £5,000, and that really will depend on the nature of your application. And I would say with any technical invention, there are particular patent attorneys for particular types of technical inventions, and it's really important that you find one that has a specialism in your area. Because in order to write a patent, you have to really understand what it is you're writing the patent for, and that means you have to have a lot of expertise in that area. So if I could cite a real life example, I worked with somebody who was trying to protect an invention that was a digital invention, and it was very complicated, and the person who was applying for the patent felt that they could probably write the patent very well themselves, and I think that's probably a true statement in that case. They were the particular person who had the particular specific technical knowledge to be able to write out what that patent really was. However, and the IPO really stressed this, it's in the nuance of the way that you word things sometimes that can trip you up. And patent attorneys speak the language, and it is a very different type of thing to write. And at the IPO, when we went for this masterclass, the person who was talking to us, particularly around patents, said, "Can you write a patent?" and showed us a product, and each of us wrote a patent. And the person from the IPO went by one and really just pulled our patents apart. And okay, you know, perhaps they weren't particularly technical, but a number of the reasons why those patents that we drafted failed were because we hadn't phrased things in the right way, or we haven't been specific about the right types of things that we needed to be specific about. And it's very important, I think, with any patent that you seek a bit of technical advice and a patent attorney around filing a patent. The advantage of a patent is they can last usually 20 years if you file in the UK. The first 5 years is covered by your patent application cost, and then you have to pay to renew them every year after 5 years, up to 20 years. After 20 years, that's it. They're done, and that's because there is a finite timeline because you've created a monopoly, and after that 20 years you should have received enough commercial advantage that then that technical invention is available for the world to use and develop and commercialize, so that we don't create monopolies around technical inventions. IPO top tips for patents. So yeah, as I've alluded to, keep your inventions confidential. Any conversations, anything written down, emails sent, presentations can be held against you at point of application for a patent. It's really important to think about using non-disclosure and confidentiality agreements if you're developing any technical invention with either people inside a company that you're working with, or in partnership with others, or with third-party providers. You can search for existing and similar inventions. So just as you can search for a trademark on the IPO's website, you can do a patent search. And as I've alluded to, seek help from a patent attorney to draft your application. Patents are particularly useful for licensing, so others can make or use your ideas and pay you royalty fees. So that's a useful reason for having a patent. I think that's particularly important where perhaps you're an inventor but not a manufacturer, and you'd like to patent the invention so that other people can manufacture it, and in which case you can license out. People can use your patent to manufacture your goods. And patents really are the best protection against reverse engineering. So we'll talk shortly about trade secrets, which essentially are null and void if somebody can take apart your product and work out how you made it. However, a patent offers some protection around reverse engineering. So if you have an inventive idea and you think, as soon as I make this, everybody's going to copy it, and people in countries with very cheap manufacturing rates like China can make it far cheaper than me, and nobody will want to buy my invention even though I was the person who invented it. In that case, a patent would be really useful because you can protect the idea, you can choose to license out the manufacturing, and you can prove when other people are infringing on your patent. Moving on from patents, we're going to touch on copyright now. And copyright is very different from patents in that copyright really is something that covers creative inventions, so creative works. So copyright is a type of intellectual property which can be bought or sold, just like the other types of property, and allows creators to gain rewards for their efforts. So the reason copyright is so important is if copyright didn't exist and you created something, everybody could immediately take that creation and use it for themselves. So why would anybody create anything? You wouldn't. You'd just wait for somebody else to do it and steal their idea instead. It gives you no protection if there was no copyright. So copyright protects your work and stops others from using it without your permission. It's automatic. So as soon as you've created something, you have copyright over that creation. So it's free. But because everybody has it and it's free, it's everywhere, and it's very easy to infringe. So I think perhaps if you're listening to this presentation and you don't feel that you're creating IP, it's also really important for any individual or business to understand what IP others have and what their rights are, because it's very easy to infringe, particularly copyright, but the IP rights of others, and it's your responsibility really to make sure that you're not doing that. Copyright, so your economic rights under copyright refers to your exclusive right as the creator to authorize or prohibit the reproduction, distribution, rental or lending, public performance, communication to the public, or adaptation. Adaptation is a really important one. It gives you the exclusive right to control that. So you can authorize people to do it, or you can prohibit people from doing it. What can be protected by copyright? Well, as I've alluded to, really, they're creative works, and those can be broadly divided into two camps. So we have authorial works, so they might include literary works, song lyrics, manuscripts, computer programs, commercial documents even are copyright, and that's important when we come on to trade secrets. Dramatic plays, dance, music, so if you've created musical score, artistic designs, which cover really designs, sculptures, photographs, diagrams, and entrepreneurial works, which are sound recordings, films, and broadcasting. So I would say, as we go through this presentation, you'll note that a number of IP protection will overlap. So if you've created a creative design, it's going to be automatically covered by copyright and a design right, but neither of those are formalized rights. So it is worth thinking about, if you've created something, whether you can register that as a registered design if you'd like to pursue some protection around it. So in terms of determining ownership for copyright, it generally belongs to the creator, but there are some exceptions. So I think probably these are relatively specific, and you can have a look through those. Broadly speaking, the employer owns the copyright of work if an employee produces it in the course of their employment, and you can differentiate, generally speaking, if an employee has created something that is part of their day-to-day role at your business, or part of a specific task that you've given them to do for the business, then the business would own the copyright. If they're employed by the company but they've done it in their own time and it doesn't relate to their day-to-day activities, they would own the copyright. And exceptions around that would really be in the employment contract. So if you're involved with a business where you have employees who are creating things on your behalf, it's really important that you think about whether the employment contract that you have in place covers the types of creative undertakings you're asking them to do, and ensures that the copyright rights lie with you as the business rather than the individuals who are doing the creating. If you've employed a contractor or a consultant as a third party, then they will own the copyright, again, unless that's specified in the contract that you have with them. So it's important at the point you employ a third party to think about that, particularly if you're using a graphic designer to design something for you, or a photographer. You need to establish whether you have the right to use, adapt and distribute those creative works. So it might be that they've taken a photograph for you, but actually what you want to do with that photograph is change it. You want to edit it, chop it up, put filters on it, and do all kinds of weird and wonderful things so it's fit for purpose for you. Well, it might be that you have the right to have the photograph and present it and distribute it, but you don't have the right to adapt it. And it's the creative professional who has those rights. So if you particularly know that you need to adapt something that you've had done as part of a third party service, that you have the full breadth of rights over the work that has been produced. Have I covered everything there? The creator can assign or transfer the rights to another party, so you can do that through a contract. And copyright does allow for licensing and collaboration agreements. So you need to think carefully. If you've done something together, are you sharing the copyright, and how is that agreed? Or perhaps somebody else has produced something and actually they don't want to transfer the copyright rights to you, but they would like to license it to you, and you could pay a fee to use their creative works, and that's very common. Copyright lasts for an incredibly long time, especially given that it's an automatic right. So literary works, films, music, dramatic and artistic rights last until death, plus 70 years after that. So if you've created something and the royalties go to your next of kin at the point of death, nobody else can infringe on that copyright for another 70 years after you've passed away. And that becomes interesting as we get further into kind of modern history and further since copyright came about, really, that there are things where the copyright are running out, and therefore a good example would be perhaps with literary works. So the very, very old literary works, the classics now, fall outside of copyright. And that means you wouldn't necessarily be infringing on a copyright if you were to use and adapt or distribute those works. But certainly authorial works which have just been written, they're going to be covered for a really long time from the point that they were written. I've covered the other lengths of time in terms of copyright, so that's really interesting to note if you're creating creative works. Top tips from the IPO around copyright. It's really important to record your work. So if you have written a piece of music, but you haven't written it down anywhere, you have no way of proving that you have created it. So think about, if you're creating works, how you're going to prove that you created them and when you created them. So keep proof and use contracts to protect copyright. Think about what licensing opportunities you might have around your creative works. There are no official registers for copyright, so it might be that you'd like to pursue protecting your creative works through one of the formalised forms of IP protection, which might be trademarks or registered designs. Confidentiality, trade secrets, and working with others. So this is a really important area of IP, which I think applies to nearly everybody who's doing anything. There are formal ways of protecting your intellectual property, but you can also, to some degree, protect your intellectual property by keeping it a secret, by keeping it confidential and ensuring that others who might have to know about your secret understand that that's confidential and they're not allowed to share it with anybody else. So around that, I've made a list there about the types of hidden IP that you might have that you should protect. Knowhow and Showhow is a good one, and one that the IPO really stressed. So if I could give a manufacturing example, that's fairly straightforward. If somebody is working in your business and they operate a machine, but they know that by using a certain amount of lubricant with the machine, or running the machine at a certain rate, or letting it heat up for a certain amount of time first, makes that machine perform better, that is know-how. And that person might never write that down, but it's really important IP. It means that if you sold that machine to a competitor, that competitor might not be able to make the products you're making, or they might not be able to make them as well, because they haven't got the experience and the knowledge required to make that machine perform optimally. So that know-how, or show-how as it's sometimes called, is really important. So the IPO talk about trying to download the IP that your employees might have, or that you have, write it down and then protect it, because that shows that the IP exists, you knew about it, you created it, and it belongs to you. So in this example, if the person working at the manufacturing business wrote down that know-how, that is then copyright, and those rights belong to the business because it was part of the employee's day-to-day role. That means if that employee left that business and went to work for a competitor and took that know-how, and you could say, hang on a minute, you weren't doing that before, and now our employees come to work for you with their know-how, you're doing something which is competitive, and we're losing our competitive advantage. Well, you can prove that because you have the copyright to that know-how and you have recorded it. So think about keeping an inventory of know-how. So think about formalizing processes that you just tell people or show people. Write it down and keep a record. Customer lists can be protected through trade secrets and through confidentiality. So ensure that things like your employment contracts specify that things like customer lists cannot be taken with somebody, because clearly an employee could remember a list of customers and take it to a competitor, which can be a major competitive disadvantage from you. Methodologies, technical information, anything like that that you commonly use in a day-to-day capacity that you can write down or represent visually, can be kept in some kind of IP inventory. So it is really important, I think, for all individuals and businesses who are commercializing their ideas or their intellectual property to think about how they're recording and protecting and managing their IP. So if you're working with a lot of others, is it important that all of those people know all of your trade secrets if you're keeping those things confidential? So can you formalize them? Can you keep them discreet on a need-to-know basis? Where you can't keep them discreet, are there non-disclosure or employment agreements in place that protect that person from taking that IP with them if they leave or using it for their own advantage? If you're not sure about non-disclosure agreements really are just a way of formalizing that somebody is not going to share information that is subsequently shared with them. There are templates for non-disclosure agreements on the IPO's website that you can use. And importantly, I did touch on this before, but I'll just revisit. If somebody can discover your secret through reverse engineering by taking something apart and looking at it, it can't be protected by a trade secret. And the only way to protect something like that would be to pursue a patent, or potentially by registering elements of that product as a registered design. But trade secrets wouldn't apply in that respect. So that's a lot of information that we've covered in this session. So it's a broad overview of intellectual property, what it is and what protection is available. But in terms of what you can do next, there's a great resource for everybody in Worcestershire at the Hive. Anita's already talked about the BIPC, so you can contact the BIPC for some more information and some of the services that they provide, one-to-one IP information sessions where you can discuss your IP. Clearly, this has been a great overview, but it doesn't talk about your individual interests or areas that you might be working in, so you can book a one-to-one. IP clinics with an IP attorney, and further support and information about IP. So those services are free to access, but you do need to book them in advance, and you can do that using the email address above. The information that I've shared today has been presented in partnership with the Business and IP Centre Network, so that's the BIPC that we've referred to, which is part of the British Library, and the Intellectual Property Office. And I'm presenting on behalf of Worcestershire Innovation Network, which is a county council initiative for innovators. And feel free to find out more about WIN through Anita also. So I think that concludes neatly the presentation. We've got about 9